Good evening and welcome to the launch of Volume 46, Issue 3 of the University of New South Wales Law Journal. On behalf of the Journal, I would like to begin by acknowledging that we are gathering on the unceded land of the Gadigal people of the Eora Nation. I pay my respect to their elders past, present and emerging, and extend that respect to any Aboriginal or Torres Strait Islander people present tonight. My name is Matilda Grimm and I am the Executive Editor of the University of New South Wales Law Journal. It is my privilege to kick off tonight's official proceedings for the launch of Volume 46, Issue 3. My thanks to Herbert Smith Freehills for hosting tonight's event and for their long and continuing support of the Journal. This year marks the 41st year of our relationship. It is a relationship that has preceded all of our time at the Journal, and I hope it will continue long after we have left. It is through the generosity of our sponsor firms that we are able to produce each issue of the Journal. My thanks in particular to Elizabeth Pittaway-Burnell for all her work organising and advocating for this launch. I must also recognise the endlessly generous support of our other premier sponsors, King & Wood Mallisons, Cause Chambers Westgarth and Allens. There are several other people whose support is integral to the Journal's success. Our brilliant faculty advisors, Professors Rosalind Dixon and Gary Edmond, who always lead with a steady hand, and Professor Andrew Lynch, Dean of the UNSW Faculty of Law and Justice, who is a great champion for the Journal and whose ongoing support we treasure immensely. Over the past few days, Professor Lynch has gone above and beyond to make sure this launch goes ahead, and we are ever thankful for his generosity in agreeing to deliver the vote of thanks at the conclusion of tonight's proceedings. Thank you too to the authors who entrusted us to publish their works and for engaging so professionally with us. It is fantastic to see some of you here tonight celebrating your achievement. There are various other parties whose direct and indirect support ensures a night like tonight can happen. Printers, typesetters, cover designers, photographers, videographers, UNSW law staff, peer reviewers, family, partners, friends, the list goes on. But undoubtedly the most important contributors are our editorial board members who edit for hours and hours with passion, good humour and rigour. The Journal's editing community is by far its greatest achievement. There is a certain group of people who go above and beyond to make sure this Journal thrives. Our executive committee, currently comprised of 6 issue editors, 1 digital editor and 1 forum editor. Although tonight we are first and foremost celebrating the achievement of Ella Davidson, the issue editor for issue 46.3, producing the issue is an immensely collaborative process. Not only is each article edited by no less than 7 editors, but countless hours are also spent debating AGLC provisions, developing our own editing policies, and arguing over the use of Oxford commas. Much administrative work also goes into making a night like tonight happen. I always take the time at this point to make special mention of our digital editor, Zong Guan, who plays such an important but at times invisible role in bringing us together. But the person who has spent the most time working on, and I know at times agonising over this issue, is Ella Davidson. She has spent literally countless hours ensuring this issue could make it into your hands tonight, working at times late into the evening and from all corners of the globe. Ella's time on the executive committee has been all too short, but she has made the most of it, advocating fiercely for the advancement of the Journal. We are sad to lose Ella, but are excited to welcome her successor, Jack Yasuda. Thank you to all of you for joining us at the launch of Volume 46, Issue 3 tonight. It is now my pleasure to introduce Ella Davidson to speak a bit more about what went into preparing this issue.
Thank you, Matilda, and thank you all for joining us tonight. Tonight's launch is in part a celebration of another successfully published issue of the UNSW Law Journal. A celebration of legal scholarship, the issue comprising 10 thoroughly researched and thoroughly referenced articles by 24 thought-leading thinkers from around Australia. It is also a celebration, of course, of you, the editors of the UNSW Law Journal, both general members and the executive committee. In choosing tonight's theme, rights, recognition and reconciliation, I had also hoped to be able to celebrate a step forward in Indigenous recognition and reconciliation following a yes vote in the proposed Indigenous Voice to Parliament. Reflective of this, the issue begins with the lead article by Gabrielle Appleby, Ron Levy and Helen Wallen, Voice versus Rights, the First Nations Voice and the Australian Constitutional Legitimacy Crisis. This article centres on the potential of the voice as compared to anti-discrimination rights to resolve what the authors name a crisis of constitutional illegitimacy and to achieve Indigenous justice. It is, however, in the wake of the no result of last week's referendum that it is not a time of celebration and in fact a time of disappointment and painful mourning for many. Unfortunately, His Honour Judge Matthew Myers, AM of the Federal Circuit and Family Court of Australia, is unable to join us tonight to give us a keynote address as originally planned. Many Indigenous members of our community are observing a week of silence to help audience members understand this. The UNSW Law Journal would like to take the time to display some words by prominent Indigenous film and television director and producer Rachel Perkins. I'll give you some time to read through that. I want to also acknowledge that there are many non-Indigenous allies, including many legal practitioners and members of the legal academia who've worked tirelessly on the Uluru Dialogues in advocating for the referendum and on the Yes campaign, and for whom this is also a time of pain and silence, which we respect here at the UNSW Law Journal. Out of respect for those observing the Week of Silence, and also in recognition that this journal was edited and is now being launched on unceded Aboriginal territory, we have decided not to feature a keynote speaker. I do want to thank HSF, and in particular, thank you, Elizabeth, for your ongoing support of the journal, especially during this trying time where we're continuing to launch, albeit in not the manner we originally imagined. Together, rather than speak specifically to recognition and reconciliation, as requests by the likes of Rachel observing a week of silence, I want to redirect our discussion to justice and rights for all of us living in this country. Issue 46.3 is a publication that certainly helps us to do that. Common to all the articles in issue 46.3 is the imagining of a better Australia, whether for all Australians or for Indigenous Australians, elderly Australians, Australian victim survivors of domestic and family violence, Australians who are recipients of or victims to manifestly unjust criminal sentencing, or Australians who have been defamed. In the issue's second article, Reparations and First Nations Legal Rights in Australia, Bethany Butchers, Danny Linder and Amy Maguire examine how reparations for Indigenous Australians can better centre and address intangible loss. In particular, Butchers, Linder and Maguire analysed loss to Indigenous Australians through 2 case studies of the stolen generations and dust diseases. Although, as mentioned, now is not the time to discuss reconciliation in this week of silence, I personally look forward to further scholarly mainstream discussion of this approach in addressing injustice towards First Nations Australians. As editor, I am proud of the active steps taken to centre Indigenous voices and experience in issue 46.3. For too long, legal academia has suffered from white silence and an absence of black voices. Not only does issue 46.3 contain 2 articles by Indigenous authors or on Indigenous issues, for the first time in a while, issue 46.3 also revives the practice of calling for author responses to the lead article. A response to Appleby, Levy and Wallen's article will soon be published in the UNSW Law Journal's forum, and I encourage all here tonight to engage in this continuous dialogue. Moving away from Indigenous justice, 46.3 moves on to an article by Anita McKay, Laura Grenfeld and Julie DeBeljak titled A New Aged Care Act for Australia, examining the Royal Commission's proposal for human rights inclusive legislation. This article is in response to a proposal by the Royal Commission into aged care quality and safety to replace the current Provider-Centred Aged Care Act approach with a human rights-based approach. Helpfully, McKay, Grenfeld and DeBeljak critique the 5 Royal Commission proposed human rights and provide a way forward that can better address the endemic neglect, abuse and mistreatment that is taking place in our residential aged care facilities. Another article that also centres the insecurity of rights, albeit not human rights or those of the elderly, but those of civil litigants, is Sonia Willis's article, The Right to be Heard, Can Courts Listen Actively and Effectively to Civil Litigants? In her article, Willis considers how the hearing rule interacts with legislative attention to the efficient resolution of civil disputes. In calling for more active judicial focus on the right to be heard, Willis reaffirms the importance of defending procedural fairness in civil as well as criminal matters. As court processes evolved in response to the COVID-19 pandemic, it will be interesting to see whether the pendulum will swing back towards Willis. At this stage of the issue, Dominique Allen, Janina Bowie, and Dan Marr enter into the fore by arguing that the common law of Australia should recognise non-discrimination as a fundamental right. In a country without a formal Bill of Rights and very minimal express or implied rights in our founding document, such a proposal is no doubt an interesting and appealing one. However, as the authors note in their article, the common law has long allowed and in many cases contributed to discrimination, so determining the contents of an interpretively functional right is somewhat challenging. But perhaps a worthy endeavour and one that provides for interesting reading no less. Alan Bowie and Marr's article leads nicely into the next article by Oscar Roos titled The Cable Doctrine, State Legislative Power and the Text and Structure of the Constitution. Being acutely aware of the vulnerability of many fundamental rights, including non-discrimination, Roos' suggestion that because the legitimacy, scope, and application of the Cable Doctrine continues to be disputed, the first implication of that doctrine, which is the preservation of the integrity of state supreme courts, be introduced into our Constitution provides for persuasive reading. The last four articles in issue 46.3 are perhaps less so obviously linked to rights. However, they nevertheless focus on bringing to light or recognising various ways in which we might build a better Australia. Belinda Reeve seeks recognition of the role that local governments can play in securing healthy, sustainable and equitable food systems in order to harness the potential of new and existing environmental and planning, public health and food regulation. As an environmentalist and a foodie myself, I thoroughly enjoyed editing this article because it provides me hope on how little changes can address perhaps the biggest change facing us all, that of the climate. With a somewhat similar meta-awareness to Reeve, Eliza Venville, Becky Battergall and Paul Sauter use their voices to recognise victim-survivor experiences of utility abuse as to suggest strategies as to how water utility support might be improved. It is particularly insightful to be able to read from the first-hand accounts of community lawyers, water support employees, and personal advocates, as well, of course, as victim survivors on their experiences. Again, like so many issues in 46.3, I am proud that Venville, Battergall and Sauter's article centres the voices of those often without a platform. Moving to John Anderson, Mirko Barabic and Brandon Murphy's article, Correcting the Manifest Error that is the approach to manifest error in sentencing appeals. This is an article that calls to reform predicated on the recognition of how sentencing can be manifestly inconsistent and yet, when it is so, without a clear path to appeal. Anderson, Bagaric and Murphy's proposal to introduce methodologies for calculating appropriate and challenging inappropriate sentences is certainly an interesting one, but one which the authors back up time and time again with judicial extract. The last article in issue 46.3 is that of Michael Douglas, Catherine Graville and Robin Carroll, titled The Evolution and Devolution of the Offer to Make Amends Regime in Australia. Decrying 2021 amendments to the Uniform Defamation Acts for reducing the incentive of publishers to make reasonable corrections, the author's focus on practical remedy for defamed Australians brings home, again, the unifying theme of justice that ties together issue 46.3. Whether through rights, recognition, or reconciliation, issue 46.3 is one that imagines a better Australia. To bring such a hopeful issue to publication would of course not be possible without a number of important people who I would like to briefly recognise and pay thanks to. To the authors, and particularly those here tonight, thank you for trusting us and bringing your work to the world. And thank you for bearing with us throughout the finickiness of the editing process. I hope that the final product does your words justice. To the editors of the UNSW Law Journal, thank you for your constant dedication to the textual integrity of this publication. Thank you for your long nights and early mornings and for supporting me as you too can celebrate in this launch. In particular, thank you to members of the Executive Committee, Matilda, Anna, Jessie, Brad, Jack, Rowan, Zong and the other Jack. And before their time, Enrico and Hayden. I will never forget your generosity as editors, but also your support throughout the trials and tribulations of 46.3. Thank you also to Ros Dixon and Gary Edmond, our trusty faculty advisors, for your constant support. And thank you to Dean, Professor Andrew Lynch, who has guided us, particularly in the last couple of days, so that we can all meet here today. Thank you, of course, to our sponsors, in particular Herbert Smith Freehills, for hosting tonight, but thanks is also extended to Allens, Cause Chambers Westgarth, and King and Wood Mallisons. The strength and quality of scholarship produced by the journal could not be possible without your support. Thank you lastly to my family and friends, in particular to my mum and to my sister, who's here tonight. I'm glad to be finally coming home after living out of the law library for so many months. Thank you lastly to everyone here tonight for your commitment to the journal and legal scholarship that imagines a better Australia. I hope you enjoy reading.
Thank you so much, Ella. That was an editor's speech. I always find the editor's speech to be fascinating. There's so many different styles and ways of doing it, and you had to do something very different tonight, and you did so with enormous integrity. And as the journal has conducted itself throughout the week, and I really want to applaud you for that. As Ella has mentioned, it's been quite a strange week, and I thought I would elaborate a little bit on that in terms of the faculty's perspective on the week that has just been, given that I have time to do so and I think it's appropriate to do so. Ella's made reference to the discussions that she and Matilda have had with me, but around their decision about how to respond appropriately to the week of silence that Rachel Perkins called for on Saturday night, in which many Indigenous members of our community are observing. And I think we made the right decision around that, but of course I respect that people will have different views, as they have had different views about constitutional change and the referendum. And I acknowledge also that there is a difference of views on even those questions inside the staff of the faculty. So that's what universities are for. We don't all agree on all things, and there are places for us to discuss and converse and think. But at the same time, I thought I would speak quite directly on the faculty's experience of supporting the voice and the call that is made, the invitation that is made in the Uluru Statement, and what the experience of this week has been like, and make some comment then on what I see as the role of the university, and in particular the mission of the Faculty of Law and Justice, of which you are, the most important part, actually. So I thought I'd share with you that on Monday morning I actually sent a message to staff, as it turns out, in Flexibility Week, as it is called. I do tend to message staff at the start of the term, the middle of the term and the end of the term. So I was meant to write to them anyway, and I wrote to them about a couple of things. And then I did give some post-referendum reflections. And I'd like to package up the essence of that for you tonight. I write really long emails. I'll be really much shorter tonight. The first thing I said, and which I suppose you wouldn't be surprised to hear me say, is I wanted to acknowledge the work of many of my colleagues, which has been over so many years. And it's impossible to walk into our building without seeing their faces on the photographs outside the main law theatre under the heading of the Lawyers of Uluru, and in particular the work of people who are very modest and have been very respectful of the fact that their contribution is as non-Indigenous Australians to that process. And that is of Gabrielle Appleby and Sean Brennan, who are pictured with Megan Davis, who of course has been an integral part with Noel Pearson and Pat Anderson in devising the Uluru Statement and educating the public around what it promised and advocating for a vote in favour of it. And Sean and Gabrielle are alongside Gemma McKinnon, who is now at Herbert Smith Freehills, our wonderful hosts for this evening, and a young academic called Dylan Leno. Both Gemma and Dylan were working at UNSW at that time, so the whole team was UNSW based. Dylan is now a very fine academic at the University of Queensland. So I certainly wanted to acknowledge just the enormous effort that they had all made over many years. And I have spoken to each of them this week and tried to sort of understand how they must be feeling. But of course, it's incredibly complex to work so hard and so publicly for so long, and for that to end as it did. And then I wanted to offer some reflections to the faculty generally around what is the role of academics in public debates about the future of society, and law's role, in particular, around transformation and justice. There were two aspects to why I felt the need to do that. One is academics, including those that I've mentioned, but also many others, have been the subject of really quite amazingly vicious attacks, both on social media but also in columns in the mainstream press, of which I had some very small taste, but I know others had a sustained exposure to that. And it really, none of those people would say that what they were doing was in any way brave, and it shouldn't be brave to voice opinions based on your expertise. But the treatment was really quite appalling, and a degradation, really, of our public debate. The second part, though, which I think is the more insidious, is a general resistance to and hostility to the value of academic expertise. And this is expressed, as it was on the night of the referendum, as a rejection of views that had been advanced by inner city academics and activists. With that interesting characterisation, denying, of course, that in terms of the photograph that I've just mentioned, which was at Uluru, the Uluru Convention of First Nations people, being the culmination of regional dialogues all over the length and breadth of this country, academics not sitting in Lower Randwick, but actually travelling to Indigenous communities and working for days at a time with them in developing options for what constitutional recognition might look like. So the mischaracterisation that inner city academics never leave the inner city, I'll park that, we do. But the discussion of academics and activists and the reference to them in a pejorative way. Now there is, and importantly, there is a difference between academic work and activism. Academics are qualified, they are expert, and they should be evidence-based. Activism is very driven by experience, but of course there isn't a strict bifurcation of those two. Activism often relies upon evidence-based material generated by experts and knows how to marshal it in making a case, in advocating for change. Similarly, academic work is often enhanced by the benefit of experience. Examining how arguments developed in the abstract or derived from theory actually may work in practice. So although I think they're often presented as academics and activists as a sort of conflated group, there are differences between them, but also there is clearly a relationship. What then is the value of academic work? And I think Ella spoke, and very diligently went through the issue and spoke of the work of the 24 authors that she and others in this room have worked so hard to bring to publication. And I had them in mind when thinking about whether I would add this tonight. The idea of academic work as neutral expertise, which isn't connected to advocacy, is an interesting one, and it's a complex one that, as one of my colleagues said to me this week, is ultimately a very personal decision. And because of the principle of academic freedom, individuals inside the university make their own call on how and when and whether at all they participate in public debates. And I think there's an institutional question around that too. UNSW as a university and the Faculty of Law and Justice independently both pledged institutional support to the promise of constitutional change and the idea of the voice. Not all institutions did, not all universities did. And I can see arguments for why some institutions would not and others were keen to do so. One argument that an academic at another group of 8 university put to me is that once you start taking a side in any public debate, the question is why you aren't then taking sides in others. And also it's easy for for commentators, politicians and so on to characterise universities as having a particular political leaning. I actually have time for that argument. And I think any institution, not just universities, but presumably also corporate Australia, has to think through those issues and really wonder about what the trade-off is in terms of being public about their pledging their support for things. And this takes me towards the Faculty of Law and Justice, because then I ended my message to staff saying for us it's actually very simple, because the founding ethos of the faculty is that we are interested in society, we are here to make a difference. And the other thing you walk past whenever you come into the building are words that I quote probably every week in some forum or another, often though at O-Week events or open days, when I talk about Hal Wotton, the founding dean, who said that a law school should have and must communicate to its students a concern for those on whom the law bears harshly. And although I do say that a lot, it's not spin, it's not some tawdry bit of branding or marketing. It's actually an enormous responsibility that is baked into the origins of the faculty. And how individual academics pursue that responsibility depends very much on their field. Certainly the private law academics working in commercial law have their own manifestation of that. Remarkable work is done around the work of trusts, the regulation of charities, access to digital tools relating to finance, housing. There is a whole world of work that happens in the faculty outside of my sphere and that of the Lawyers for Uluru, of public lawyers. But it's a mistake, I think, to think that those words apply to certain parts of the academic activity at UNSW that actually suffuse everything that everybody does. I could point to some aspect of everybody's work that would relate to that, not just in criminal justice or public law. And those words are important for us, obviously, as researchers and when we think about public debates, but they're also, central to our teaching mission. The label social justice is often applied to them, and that is perhaps a convenient shorthand. But I think, and if you cast your minds back, and it may be a few years, it may not be that long at all, to readings that I think are still used in introducing law and justice, what Hal Wotton was talking about is professional responsibility. It's not necessarily social justice as we understand it in 2023, but what he was saying when setting up the law school is you're entering a profession. So what we need to communicate to students is that it comes with enormous privileges and rewards to work as a lawyer. And associated, though, with those things is a responsibility to think about law's operation and those upon whom it bears harshly. The Yes campaign for voice was entirely consistent with the tradition of the faculty based around those words, and was really just the latest manifestation of that, 52 years after we welcomed our first students. So for us, committing to that campaign was uncontroversial. It was not a hard decision. The result has been hard to take. This issue is so consistent with that theme and is shows the variety of ways in which that idea is applicable in so many different aspects of law. And it's a very fine addition to the canon that is the UNSW Law Journal, and not least because of that. My role is actually not to make speeches. I'm meant to give votes of thanks, aren't I, Matilda? So I'm now going to move to the vote of thanks, and which I'll do very briefly because I think some thanks have already been given, but it's always a pleasure to recognise hard work and achievement and contribution, and I do so from a different vantage point from both Matilda and Ella. I do so as the beneficiary or a representative of the beneficiary, which is the Faculty of Law and Justice, which is a separate institution from the Journal. The Journal is fiercely independent, and the faculty is incredibly proud of what it achieves with that independence and has enormous respect for it. So firstly, I thank all of you. I thank all of you for coming. Having thought long and hard about whether this event should proceed, it's wonderful to arrive and find people here who are talking to each other and saying how glad they are to be here as well. So a launch needs and deserves an audience, and you have provided us with one. So thank you for being here. I also obviously add my thanks to those which have been given to our good friends and sponsors and hosts tonight, Herbert Smith Freehills, for making us feel so welcome, as is always the case It's really wonderful to be here. I also would thank and acknowledge my colleagues, Roz and Gary, who unfortunately aren't able to be with us tonight, but who greatly enjoy working with each year they work with a different team in the journal, and they greatly enjoy that experience, and I'm sure they're very useful and wonderful sounding boards for lots of ideas. I then obviously thank Matilda as the executive editor for this year and the whole editorial team. It's a really remarkable collaboration, and it goes so fast. It feels like you've just arrived. There's only one issue left for the year, but it's been really wonderful to see the third issue come out for this year, and the work that is done by the whole group is something which never ceases to impress and amaze. And I spend a lot of time telling people that the journal is absolutely arm's length from the faculty. And I don't know why some people struggle to understand that, because I doubt the faculty could produce a publication of such consistent quality and on time. The work ethic that goes into it would be a challenge, I think, for some of us, self-included. And now I come to the last thank you, which is obviously to Ella Davidson, and it is accompanied by a congratulations, because to produce this issue is an incredible achievement. And as I think I have said on other occasions, although there are many authors, many footnotes, many editors who have seen to those footnotes, so many hands, it's absolutely collaborative, but it is also remarkably personal and individualised. And whenever I pick up an issue, I try to remember, without cheating, who the issue editor was for the last couple of years, and each launch sort of comes back to mind. So congratulations, Ella. Those long nights in the library. It's a library with a microwave. I don't understand that, but it's probably useful to you. I'm of an age where the idea that you eat in the library seems quite inappropriate, but if you're going to work these kind of hours, that's a good idea. Those are all behind you. This is now something really to be proud of. It will be something that stays with you for the rest of your life. It'll be on a bookcase when you're moving house, and in 30 years' time, you say, that's not going out, that stays with me forever. It'll be a line on your CV, it'll be something people ask you about forever. It also is membership of a really wonderful club. You mentioned your sister. It's great to have her here tonight. I know your mum isn't able to be here, which is a huge shame, because family is very important to supporting issue editors. But there is also, and I'm not going to say the family of the journal because that would be quite sick-making, it'd be too cheesy, but the support of the journal team is everything. And, I know that the community, which I think Matilda said beautifully, is perhaps the journal's greatest achievement. I've never heard that before. That's a winning line from an executive editor in the many years I've been doing this. That really is, I think, certainly a very great achievement that the journal has. It's a remarkable publication. It's a remarkable group of people. Thank you for being here tonight. Congratulations, Ella.
Thank you, Professor Lynch, for as always speaking so highly of the journal. That brings tonight's official proceedings to an end, but please feel free to remain and mingle for another half hour or so. And don't forget to pick up your complimentary copy of the journal before you leave tonight. The issue will also be available in digital form on the journal's website from tomorrow. Thank you, everyone, and good evening.